Aloha, this is Carol Richelieu, President of the Senior Counsel Division. We're very pleased to welcome you to our presentation today. It's all about closing the law practice and succession planning. Those of you may know that it's a topic that I've been harping about for years, probably decades. Our presenter today, of course, is Bradley Tamm, who is the Chief Disciplinary Counsel and Administrator of the Lawyers Fund since 2018. His background is solo, admitted in Hawaii and California, and in bankruptcy. I've had actually the pleasure of knowing him and working with him since 2006, and we work together on various topics. Before we begin, I would like to give a little plug to HSBA's Transitioning Lawyer Committee. The committee has a wealth of information online with the HSBA on this very topic. So we would like to encourage folks to also go to that. And so now I'm going to hand it over to Bradley Tamm. And trust me, he knows what he's talking about. Thank you.
Thank you, Carol. As my predecessor and the person from which I learned the most from. It's always appreciated to work with you. Good morning. I'm Bradley Tamm with the Office of Disciplinary Counsel, and joining me here today is Assistant Disciplinary Counsel Ryan Little. Mr. Little will be controlling the slideshow. He will also be monitoring your chat questions. Now, I'm not here to talk to you about discipline today. I'm here to talk to you in my other capacity. That capacity I jokingly refer to as Chief of the Dead, Disabled, Disappeared, Disbarred, or Deported. Well, that's a joking title. The real title is Disciplinary Board's Trustee Administrator. Now, today's presentation, without interruption, will take about 28 minutes, and we have a whole hour or 55 minutes or so. So I built in time for you to ask questions. If you have questions, please use the chat function in this Zoom session. Mr. Little will be monitoring the chats and will interrupt me to orally repeat your questions where appropriate. If the question is appropriate to what we're discussing at that moment, he'll interrupt me. If it's a general question that seems somewhat off topic, he may decide to hold that question till the end of the presentation. However, if we run out of time and you don't get your question answered, you can always call me directly or send me an email. Okay, so let's begin. Okay, we got control of the share screen now. Okay. This is the slide we want to be on. Dealing with lawyers as they age out of the profession is expensive. It's expensive to us all. Each year, all of us lawyers pay our dues to renew our license to practice law. And out of the fees collected, about $200,000 is spent to protect the property interests of clients who have been abandoned due to their lawyer's death, disability, disappearance, disbarment, or deportation. Today, we're going to look at strategies of prevention and planning. Preventing unnecessary expense and planning to provide a smooth transition. Now, hopefully, nobody here today will disappear, be disbarred, or suffer deportation. But all of us will ultimately fall to the ravages of time. Death or disability, that's a certainty. Slide, please. Last year, the Supreme Court approved a comment to HRPC Rule 1.3, that's the rule of diligence, to suggest that each sole practitioner prepare a plan for succession, or at least to provide for some other lawyer to protect clients in the event of death or disability. Did we lose our screen share? Oh, glitches today. Oh, wonderful. Okay, so today, in this short hour, we're going to touch upon 4 important points in this process. 1, is it better to have a successor or designated practice administrator? 2, who pays the cost? 3, how can you prepare so as to lessen the burden? And 4, what liability risks or immunities are available for the lawyers who step in to help? Slide, please. Okay, so let's talk about early planning, succession, or court intervention. Assume for just a moment that the great tragedy happens. You are no longer around to perform your professional functions. Sooner or later, the Grim Reaper finds us all. So are you ready? Well, that will depend upon whether you have taken the time to prepare. So let's explore the difference between a succession plan under the rules of professional conduct or trustee proceedings under the rules of the Hawaii Supreme Court. Slide, please. First, look at your practice circumstances. If you're in a partnership, law firm, or work for the government and have nothing left over from a prior life as a solo practitioner, you're covered. Your partner's firm or agency is responsible to wind up your professional practice affairs. However, if you're a solo, then you need to ask the question, do you have a busy practice with numerous viable projects? Are you doing hourly work that pays regularly or have contingent work that is likely to result in significant revenues for you? This is a kind of practice that could benefit from a succession agreement. Or is your solo practice slowing down? You have a few open cases. You're earning just enough to keep the doors open. The clientele are mostly longstanding clients that have come to rely on you, and nothing juicy enough to entice another lawyer to want to take over. This kind of practice is in need of a designated practice administrator. So let's take a bit deeper look at these options, starting with the successor option. Slide, please. Succession agreements are a great way to deal with the transfer of a viable law practice. The rule of law practice succession is at HRPC Rule 1.17. That is the rule for sale of a law practice. When you're looking at the sale of a law practice, you also want to keep in mind Supreme Court Rule 6, which has to do with professional business organizations, as that may impact your succession plans. Now, while HRPC Rule 1.17 appears to deal with an immediate or present tense sales, I personally see nothing in the rule to prohibit a contingent springing or contingent reciprocal sale. But bear in mind, I'm not a judge. I don't wear the black robe. So what I say isn't law. But I'm just going to go forward today with the assumption that you can design a succession plan that triggers upon a circumstance like death or disability. So let's look at the rules requirements. The seller must cease to engage in the practice of law. Well, that's not going to be hard to fulfill if you die. Pretty hard to practice law from the grave. Or if you become disabled. So paragraph A is satisfied. Next, the entire practice is sold to one or more lawyers or law firms. So you can have this deal set up where the practice is transferred to one lawyer, or it could be a group of lawyers. It's up to you to design it. Okay. C, the seller must give written notice to each of the seller's clients. Now, take a look at the rule carefully to see the details on what this notice has to contain, or where you can't locate the client to give them notice. But you got to give notice. And the fees charged to the clients shall not be increased by reason of the sale. That means that your original agreement with the client has to be honored. So perhaps you have a colleague with a similar kind of law practice. Perhaps you could form an agreement between the two of you that in the event of or contingent upon your death or disability, the survivor takes over the practice and substitutes in as the attorney of record. Your agreement could include reasonable terms for dividing fees in some reasonable proportion to the work being done. That is, some portion of the proceeds to be paid to the seller or the seller's estate. Now, be careful now. You want to exercise care when you're talking about fee splitting. The rules of professional conduct talk about that. And if you have questions, you can call us here at ODC. We'll be happy to walk you through it. Okay. To put the advance agreement into place, you would need to send notices to your current clients, or as to future clients that you're going to obtain in the future, put this notice of succession into your retention agreements, your fee agreements. This is sort of what I like to look at, call maybe an advanced healthcare directive for your law practice. The nice part about succession agreements is that they can be a win-win situation for both the seller and the buyer. And also, you could set it up, arguably, as a mutual and reciprocal agreement. You know, we're gambling here. Who's going to go first? That's the question we all ask from time to time. All right. More importantly, a properly orchestrated Rule 1.17 succession plan avoids the need for ODC and court intervention later on. That means the profession doesn't need to spend your license fees and revenues to wind up the affairs under Supreme Court rules. Think, if everybody had one of these succession plans, your annual license fees could be reduced. But not everybody's practice is set up where this is the right solution. So let's move on to the next choice. Slide, please. Let's look now at the designated practice administrator as an alternative to a Rule 1.17 successor. Designated practice administrator is defined in Rule 2.20 of the Rules of the Supreme Court of Hawaii. This rule provides that where an attorney is no longer able to practice law, has no partner or successor, the ODC needs to get involved. ODC will likely ask the Supreme Court to appoint a trustee. But if you have designated a practice administrator in your annual bar registration, you can influence the court by identifying a particular Hawaii lawyer, the one you want, and hopefully one that has agreed to serve as a trustee in winding up your practice. This can make a big difference in how your affairs are wound up. ODC selected trustees usually cost money to you or your estate. However, where you choose a designated practice administrator, they are usually your friend who serves pro bono. This can save your estate and your fellow lawyers a lot of money. So what happens when your time has come? At ODC, upon learning of the death or disability of any lawyer, first thing we do is pull your most recent HSBA registration document. We first ascertain the nature of your practice. Are you listed as active or inactive? Are you a sole practitioner or are you in a law firm? If you've indicated you're in a law firm, ODC will then contact the firm to verify that it is handling the situation. We also ask some questions to see if any special circumstances are present. What kind of special circumstances? Well, occasionally the deceased lawyer used to have a solo practice before joining the firm. However, when the form was firmed, the firm specifically excluded and declined any responsibility for that prior practice. Those situations will require special handling. Also, there's the occasional law firm guy whose firm, it turns out, is actually a sole proprietorship. And all the apparent partners were merely employees of the dead solo practitioner. Well, that's another special problem that takes special handling with ODC. Okay, now where the lawyer is listed as a sole practitioner, ODC looks next to see if a successor or trustee has been identified in your bar registration. You may recall this question. It's a question number 10 in your annual bar registration that asks if you've designated a successor or a trustee. Where a name is found in response to this question, and really that's quite rare, as it only happens in about 6% of the cases, ODC then contacts the designated person to verify that the designation is accurate and that the designee is able and willing to perform. Yep, I had one lawyer who passed away. Sorry, phone, got to turn it off. Yeah, I had one lawyer who passed away, and I was pleased to discover that the lawyer had designated a trustee in the bar registration. So I called that designated trustee, and you know what that designated trustee said? She did what? No way. Yeah, it happens. He was quite surprised that he'd been designated as a trustee. He had no knowledge of it. Whether it's true or not, I don't know. The lawyer died. So the successor sitting out there, well, if that person declines to take the position, the only thing ODC does, there's no punishment to the person who declines. We just move forward and act as if no trustee had been designated. Okay. Bottom line here between the successor and the designated practice administrator is successors succeed to the law practice and ODC is done. But where no successor is identified or ascertainable, ODC will proceed with the case as a candidate for appointment of a trustee. Now, at this point, it is important to make something clear about trustee proceedings under Rule 2.20. The trustee is only appointed to protect client property. The client property generally is just the client files and funds. A trustee is not there to take over the property interests of the deceased lawyer. The trustee doesn't run the practice. The attorney's property and property interests remain the property of the lawyer or the lawyer's estate. Trustees appointed by the court don't run the practice, don't represent the clients, don't pay the lawyer's bills, or solve the family's problems. Remember, trustees appointed under this rule are there solely to inventory the client property, protect and preserve it, and get the files returned to clients. Now, where the lawyer has nominated a trustee, ODC will help guide the trustee through the initial application process and seek court appointment. Only the Office of Disciplinary Counsel can file a petition for appointment of a trustee. And we do that for you, not a problem, and there's no charge for it. But where no trustee has been nominated, ODC will seek to appoint a professional who can wrap up the practice efficiently, but usually at significant expense. In all trustee proceedings, the ODC remains involved as trustee administrator until this process is complete. All right, now, this has only been an introduction into succession and practice administration. A very brief introduction, and it only scratches the surface. The mechanics are much more nuanced, and if you don't have a plan, you should start thinking of one. ODC can't give you legal advice, but we can guide you somewhat and maybe point you towards resources that should be helpful. Always remember, when it comes to planning for succession or planning for a designated practice administrator, ODC is available, and I, as your chief of the dead, am available to talk to you at any time. My contact details are on the HSBA website, my direct line, call me anytime. And if I don't answer, leave a message. I will get back to you. All right, slide, please. Next part of the discussion focuses on the cost of court intervention. This only applies in trustee proceedings. If you have a succession agreement, that pays for itself, we don't get involved. If the ODC and court gets involved in winding up your affairs under RSCH Rule 2.20, it can be expensive. Where there is no successor and a trustee need is apparent, ODC will act to notify the banks and lock down your trust accounts. If you're dead or disabled as a sole practitioner, nobody else should have access to your IOLTA or current client trust accounts. We had one attorney that passed away, and we didn't know it ahead of time, but his wife was an authorized signatory on the IOLTA account. And the day he passed away, she issued a bunch of checks and cleaned out the client trust account. That taught me a lesson that as soon as I learned of an attorney's passing, I got to jump on it and notify the banks to lock down these client trust accounts, your IOLTA and the CTAs. As to your accounts, remember, you should only have a nominal amount of your own money on deposit. What is the nominal amount? I don't know, $250, somewhere around that. I had one lawyer not too long ago that had over $1.5 million in his client trust account. And it didn't belong to his clients either. That's what they call commingling. That's not a good idea. So keep a small amount of money in your client trust account to pay bank charges. That's authorized. But all the rest of the money belongs to your clients. Also, be aware that if you pass away and there's a lot of money in your client trust account, if we can't figure out what client it belongs to, they remain in trust for 5 years, and then the Supreme Court will order those funds to a sheet to the state treasury. That's not what you want to leave your heirs. So any earned fees should be withdrawn promptly to avoid depriving your heirs of those funds. For more details on the cost of this proceeding, I encourage you to go to ODC's website and take a look at this article here, and the URL to find the page here is at the bottom of your screen. This article was written in November of 2019, and it details the expense that could be levied on your estate should you pass away. And significant expenses be incurred. A failure to plan is a problem. So do what you can to reduce any mess that might be left behind. It's not the kind of gift you want to leave to your heirs. All right, next slide, please. ODC doesn't do this because we're mean. ODC and trustees are just following the law. The rules of court require that the lawyer or that lawyer's estate be responsible for fees and costs incurred. The question is, how much? If you have not identified a practice administrator willing to serve pro bono, ODC will try to find a volunteer, but they're hard to find. It's more likely that ODC will seek to employ a compensated trustee, and these costs will ultimately be passed on to you or your estate. Now, I keep saying you or your estate here. Obviously, if you're merely disabled for whatever reason, and you're still alive, then any judgment can be passed on to you. If you passed away, then the judgment will go against your estate. Fees can run into the tens of thousands. We even have one case that's about $160,000 in trustee fees so far. And that case is not quite over yet. It's the outlier. It's been the most expensive one I've seen. But I see these cases regularly, and with professional trustees involved, they run anywhere from $10,000 to $80,000 around that. This is money that comes out of your license fees, so take it personally. Okay? Do you really want to leave that as your legacy to your family and heirs? You or your estate are also liable for other expenses incurred beyond trustee fees. Those other expenses can include publishing notices in a newspaper. Now, most of you are my age in the senior counsel division. A long time ago, we can remember it used to cost $10 to $20 to run a legal ad in the newspaper, and it ran on 3 consecutive Sundays. That's what they required. Not anymore. Just one single small micro advertisement in the Honolulu Star Advertiser on one Sunday costs about $750. It's gotten expensive. Fortunately, the rules only require a single notice be published in a newspaper, but still, it's $750. Then also, how about the storage of your client files? I'm going to talk to you more about client files in a minute, but your client files can't stay in your office because usually once you pass away, you stop paying rent. So your landlord starts beating on my door. He wants your stuff out of there so that he can turn around and rent the space. So where are the files going to go? Temporary storage. And particularly here in Honolulu, oh, Maui's worse than Honolulu, the cost of rental space for storage. It's really, really expensive. Then we got to move the files from the office over into storage. And normally we hire a contractor to do that. That costs. Then there's the costs of inventory and segregating valuable originals and the costs of secure destruction. A lot of these things are involved with this. All costs will ultimately be reduced to a judgment and imposed on the lawyer or the lawyer's estate. All right, did I see?
Bradley, we have a question. Can you go over what client documents we are required to keep and for how long? And in what state, physical versus electronic? I'm an estate planning attorney, so tend to keep copies of documents for a long time. Thanks.
Oh, estate planning lawyers. Glad you asked that question. And I definitely have it in the materials here today. I also asked you to invite me to come speak to the estate planning section. I would love to talk to you guys about storing files, because I think if I was to take a look at the costs of handling dead lawyers' files, the nightmare that I have that keeps me up at night all come from estate planning lawyers that pass away. Because you guys are dealing with stuff that's very important documents, original wills, trust agreements, all kinds of stuff like that. And so we will cover that in just a few moments here. Okay, slide please. What can you do now to make your law practice more succession or administration friendly? Lots. I'm going to answer your question. Recognize there is no rule that requires you keep client files after termination, except records of client financial transactions. Now, here we have on your screen is HRPC Rule 1.15a. It's also repeated almost verbatim in the Hawaii rules governing trust accounts. Your financial records of transactions with the client, you're required to keep for 6 years. But many callers are surprised to learn that there's no rule that requires you to keep non-financial client records for any period of time. I love it. I get this call maybe once or twice a week. Some lawyer calls and says, how long do I got to keep my client files? I said, well, what do you think? And usually I hear the answer, 7 years. I don't know, that's the 7-year itch, was a movie back in the 50s. And the other answer I hear is 6 years based upon the statute of limitations for contract. But the truth is, as far as ODC is concerned, there's no rule that says you have to keep former client files. You might have other reasons for wanting to keep old files, but the rules of professional conduct and ODC do not mandate it, except for a few circumstances that we will now discuss. Slide, please. Okay, distinguish between a current client and a former client. Generally, current clients are clients with open and ongoing matters. Obviously, you need to have the file that includes whatever you need to represent that client, files on paper or electronic format. Former clients, however, are clients where the representation has ended. Ending a client relationship is not always that clear. Unfortunately, it is not always that clear. The law does not require in all cases any form of termination notice, but it is really prudent to do so. I practiced law as a sole practitioner or a small firm guy for close on to 30 years. And during that time, I tried, it's not always, doesn't happen every time, but it should be your standard course. And I tried very hard to do it, that at the end of every case, send a letter to your client and say, hey, you and me are pal. I'm done. I'm out of here. If you want anything, come and get it. You got 60 days. After that, I'm going to destroy everything. Did I destroy everything within 60 days? Probably not. In fact, my general practice was I took all my old files, boxed them up, sent them to storage, inventoried by box number, and 6 years later, I destroyed the contents of the box. So I had this constant rotation going through. That's better than the guy who takes all their formal files and puts them into a warehouse somewhere. We had a gentleman of our bar pass away in 2016, I think it was. And he had started practicing law about a month after I was born, 1952. And he had never thrown out a client file in all that time. Oh my God, talk about a mess. So give your clients termination notices and deal with handling the client files. Now, here's the applicable rule on your screen regarding what you are required to do at termination. So for our purposes today, let's focus on that part of the rule that says you must, quote, surrender any papers or property to which the client is entitled. Now, it doesn't say that you have to give them everything in your possession. It says papers or property to which the client is entitled. Now, when reading the rules of professional conduct, the black letter are the rules, that standards by which you cannot deviate from. You cannot fall beneath those standards. Most rules are followed by official comments. Official comments are not rules. You can't be prosecuted for violating a comment. But comments are there to help educate you and give you examples. So I always say that in the rules of professional conduct, the comments is the gold in that book. So take a look at comment number 10 to HRPC Rule 1.16 for an explanation as to what the client is entitled to receive. Note that it says all documents in the lawyer's file. And then it goes on to carve out something having to do with work product or copies that are solely for the attorney to review. So a good practice would be to forward to your client any document relevant to their representation as the documents are received. That way, there's little that you need to turn over at termination. This is particularly useful today in the modern age of Jeff's filing, or for federal practitioners with CMECF. You get these electronic documents that are sent to you with a notice of electronic filing, the emails from the court. Just take the document as you receive it, you save it to your hard drive, then forward a copy to your client. And if you establish that as your business practice, they've already received everything that came in as it came in. Then what are they entitled to at termination? They've already received everything to which they were entitled. So if you do this, and subject to any instructions from your insurance carrier, perhaps you can follow my favorite little phrase when I teach succession planning courses. If we were in a room, I'd make you all stand up and repeat after me. When in doubt, throw it out. I'll say that again. When in doubt, throw it out. Get rid of these old files. If you don't need to keep them, get rid of them. the former client file situation gets tricky, where you have what we call legally operative documents or other documents of value. I'll repeat that phrase. Quote, legally operative documents or other documents of value. This is where the estate planning practitioners' ears perk up here. This is a term of art in trustee proceedings, and it generally refers to original wills, original trust documents, executed but undelivered or unrecorded deeds, and that sort of stuff. As to this stuff, I always ask the question, why should the lawyer be holding on to this stuff in the first place? I'm sure there's good reasons for it, but would it not be better to give these original documents to the client? Whenever I drafted a will, in the short period of time that I did this many decades ago, I was trained to hand the will to the client. This is the original will. There are no copies of this document. This is the very important piece of paper. Take it down to the bank, and if you don't have one, open a safe deposit box. And then leave a note in your personal papers at home, along with the key, that says, in the event of my death, go to the safe deposit box and get my valuable documents. Why is the lawyer hanging on to it? Is the lawyer being compensated as an archivist? And if you are being compensated, are you compensated enough for both the risk and liability of handling this archive? This is a nightmare for you, and it's a nightmare for trustees to succeed to your practice. I had one lawyer who passed away, and going through his property, we found over 2,300 original wills, all nicely bound on bluebacks. And you got to be our age to remember what a blueback is. And they were printed on onion skin. Remember what onion skin was? It's a horrible process to unbind these wills, and the wills on the onion skin then crinkle or jam up in our scanner machines. And then you ever try and hunt down a Jane Doe who signed a will 40 years ago? Maybe she's dead, maybe not. Truly, original wills are documents to which the client is entitled, so ODC can't destroy them. You can't destroy them. This is another problem that we need to discuss. I can't discuss it with you today. We don't have the time for it, but these legally operative documents or original documents of value are special cases. So how do you know when to throw it out? And if you do throw it out, where are you going to throw it? Now, when I use the word throw it out, I'm not talking about the trash. Because remember, the rule of confidence, that's in Rules of Professional Conduct, Rule 1.6. Confidentiality survives termination of the client or death of the client. You're responsible for maintaining confidentiality until the end of time. And in the event of your death, the trustee has to maintain confidentiality. So when I say throw it out, what I mean is securely destroy any of this property. Now, you can invest in a cross-cut shredder for small jobs and get them at Costco or Sam's Club. But if you have a large amount of papers to be destroyed, contract with a commercial shredder for the large jobs. You can have some of these companies. Lately, we've been using Goodwill. Believe it or not, they've got a very good shredder service. It's quite reasonable in price. Access, Shred It, a bunch of these companies will come. And I think Island Movers started doing it. I don't know if it lasted into the pandemic. I do know it's getting hard to schedule these shredder companies to come to your location. We're finding now that we've got to schedule almost 4 months in advance because so many people are getting sick. So many people don't want to do this kind of work. So plan ahead with your shredding. All these tricks should be in your toolkit. All right, slide, please. Okay, so let's back up a little and talk about client funds held in the trust account. What about your trust funds? That's your IOLTA account and other client trust accounts. Who has access to your account information and whose money is held in the account or accounts? Now, in the old days, accounting records were all on paper, and after death, the ODC or the trustee would go into the lawyer's office and find the accounting records. Modernly, these accounting records are digital, and they're on the computer, and they're password protected software files. If you don't have the password available for the trustee or successor, his files are locked and we can't get to them. So do you risk telling somebody your password to use in the event of your death or disability? If you do, are you going to pray that they don't use it to rip you off before you die? That's a tough question, and it's one that we're continuing to struggle with. Okay, and then what if you do write it down and keep the ID and password in a safe place, and then later you change the password? A lot of these software programs now require that you update your password every 6 months, and you don't update the list. Well, that's the same problem as not writing it down in the first place. It's pretty hard to find out from you what your password is after you're gone. These are real problems that successors and trustees deal with regularly. I don't have a good one-size-fits-all answer, but I'm working on it. You need to think this out. You need to consult with your estate planner or call me to brainstorm a solution for you in your particular circumstances. But these are things that we need to start thinking about now while we're still vital and able to deal with problems. Okay. Now, I also want to remind you, other than nominal amounts, all funds found in the client trust account are presumed to be client property. These funds need to be returned to clients when you cease to practice. And remember, unidentified, unreturned, or unreturnable funds will escheat to the state treasury and not to your heirs or estate. So please don't put off preparing your practice for these situations, as you never know what may happen. And let me illustrate this with a little bit of personal experience. On November 4th of 2004, at the tender young age of 52 years old, I suffered a debilitating hemorrhagic stroke. And for the first few days, I didn't know if I was going to make it. At the time, I was a partner in a 2-lawyer law firm, and we had hundreds of open cases. My God, we were not ready, and this was a wake-up call. These things can happen at any time. At my age now, I sit here in ODC and I handle cases relating to all the lawyers who pass away in Hawaii. And once, twice, 3 times, 4 times a month, I get a phone call that somebody passed away. And it's usually somebody that I practice law with, a contemporary. And some of them just go to sleep one night and don't wake up the next morning. So it's not something that you can put off. It's something you need to start dealing with soon. Now, this is the time. Slide, please. So I've talked to you about succession agreements, and I've talked to you about trustee proceedings. When I've talked about this in other groups, and I did travel around to our neighbor islands and gave the presentation with the Attorneys and Judges Assistance Program, the presentation we called Endgames. One concern that was brought up many times was liability. Many lawyers are hesitant to throw in with a colleague and to take over in the event of death or disability for the sole reason of liability. Yeah, you might be good buddies and love to sit around and talk story about the old days, maybe even wager on Super Bowl results. But your buddy has seen your office. They've seen the piles of files. Do they really want to inherit that mess? Well, if you buy the log practice under the succession rule, under HRPC Rule 1.7, like anytime you buy anything, in a business in particular, you buy not only the assets, but you buy the liability. Know what you're getting into and proceed caveat emptor. But where you buy a law practice, you probably have considered this and you believe the benefits outweigh the risk. In that case, I wish you success. The alternative, however, is a designated practice administrator, or what we call a trustee proceedings. Trustee proceedings under Supreme Court Rule 2.20. Trustees, now these are the guys that I talked about earlier that go in and inventory the files, take possession of the client trust account, return the property, files, and funds to the clients. These are court-appointed trustees and they enjoy quasi-judicial immunity from suit. This is the rule that's on your screen, Rule 2.8, immunity. The trustees serve only to identify clients and facilitate the return of property, that's files and funds to the client. The trustees turn over property to any lawyer designated by the client, or the trustee engages in the secure destruction of files on the instruction of the client or destruction in accord with the rules and court orders. Now, the trustee during this process enjoys quasi-judicial immunity. And if you look at the highlighted portion on your screen, it says trustee proceedings conducted pursuant to Rule 2.20 shall be absolutely privileged and no lawsuit predicated thereon may be instituted. So if you're looking at stepping in as a designated practice administrator, a trustee in these cases, yeah, your buddy's files may be kind of messy, but don't worry about getting sued over it, as long as you just do what trustees are supposed to do. Now, what about when you walk into the office and you're taken over because your buddy passed away and you run across this one file that's really juicy? You go, geez, I don't want to inventory and turn over this. I'd like to work on this myself. There's money to be made in this gold mine. Is it possible to take over such a file? Yes, it is. In the newly revised rules dealing with trustee proceedings became effective January 1st of this year, we made that provision as an inducement to get people to volunteer for these trustee proceedings. Slide, please. Under the current trustee proceeding rules, the court-appointed trustee does not represent the client nor make appearances for the client unless the client and trustee agree to exclude the case from the trusteeship. Now, this is just one case out of many. You find this juicy case and you want to take it on, you can exclude this particular case from the trusteeship, but the trustee must disclaim immunity as to that one representational matter. Obviously, we're not going to cloak you with judicial immunity for you to go out and take over a case for which you're going to make money on. You screw it up, then when you get sued for malpractice, you go, oh no, I'm immune. Not, can't do that. The client and the trustee are required to negotiate a written understanding in accord with Rule of Professional Conduct, Rule 1.8. And 1.8, that's in the conflict section, it talks about business transactions with a client. And then once you've negotiated one of these deals, you have to notify the Hawaii Supreme Court. Remember, the court appointed you as trustee. You got to notify them that this one particular matter you're no longer handling as a trustee, you're going to handle as attorney of record. Now, these situations come up, they don't come up every day. Sometimes you find some good ones, sometimes you don't. If you do find a good one, and because of the particularities of this, ODC is there to work with you. The trustee calls up ODC and says they want to carve out one of these cases, and we'll work with you to make it happen. All right, so where did we go from here? Slide, please. I miss Leonard Nimoy. What a guy. We've come to the end of this high altitude survey of succession planning. It's been more of a menu than a cookbook. I hope you discuss these topics with your colleagues, your family, your estate planner, your tax professionals, and perhaps your insurance risk consultants. You can also call ODC and ask to talk to me as a trustee administrator, or you can talk to any of the other professional lawyers here at ODC, Assistant Disciplinary Counsel. Calls regarding your prospective conduct will be held in confidence. But like all calls to this office, as long as you don't go to court and say, hey, I called ODC and they say I could do this evil thing, and it turns out that's not what you asked ODC, then the confidence doesn't apply so much, especially when the judge issues an OSC for ODC to show up and explain why they authorize certain conduct. But all your calls here are held in confidence. Okay, we are looking to, with regard to if you do some planning and you do succession agreements or these trustee turnover agreements or something like that, we're looking to collect whatever you do and make it available to other members of the bar if you so choose to share it with us. So that if you develop one of these sale plans or a designated practice administrator agreement or something like that, if you could share it with me, a sanitized version, take out all the personal identifiable stuff. And if you're willing to share it with me, that way I can collect it. And when someone else is thinking about doing it, I can share it with them. If we all pull together to try and improve the profession and protect the public in the same stroke, we're all working together on this, and that's what I'd like to do. So in closing, and if you have any more questions, let's get them in. But I want to wish you a long, healthy, and happy life. That's it.
Okay, thank you, Bradley.
Thank you, Bradley. Appreciate it very much. We could sure trade some more stories about trusteeship someday.
I'm sure you could. Ryan, you want to stop the screen share there?
Sure thing.
Okay.
And before we wrap up, does anybody have any questions? Any burning issues, important topics about succession planning?
I have a couple of questions.
Sure, yeah. Could you please identify who's speaking if you don't mind?
Oh, sure, Stephen Gessel.
Yes, Steve.
Okay, go ahead.
If you have a contingency fee contract with a client and you decide to retire, is it okay to split that fee somehow with the new lawyer that takes over?
Transferring one case is possible. That has to be done with client consent. You have to sit down and negotiate it with the attorney you're looking to transfer it over to and with the client. The client has to agree to the transfer of it. You can't increase the fees that you're charging to the client, like you can't charge a passing on fee or something like that. And particularly with contingent fee agreements, you can retain as part of the sale price a portion of the proceeds of sale, but they must bear a reasonable relationship to the amount of work you did on the project. Now, if you did all the pretrial work and it's ready to go to trial tomorrow, maybe you're entitled to a big chunk of the proceeds if there's a successful trial. But if all you did is you did the initial intake screening and you answered a phone call and then you pass it on to a trial attorney who's going to do the pretrial work in the trial, then you're probably only entitled to a very small percentage of the contingency. That's the same in any kind of fee splitting understanding or arrangement under Hawaii law. But it's possible to do it. Rule 1.17 generally deals with the sale of the entire law practice and not what you're talking about is the sale of an individual case or proceeding.
Okay, another question. If a lawyer retires and gets a new lawyer to take over the existing cases, is it okay to pay the trust funds to the new lawyer, or does that have to go back to the client?
I'm sorry, say that again.
I believe the question is if the client has paid you a retainer fee and you retire and the client secures new counsel, are you then able to pay the remaining retainer funds as former counsel to new counsel, or do the funds first need to go back to the client who will then pay them to new counsel? Is that correct, Mr. Geschel?
Yes.
All right, thank you. I remember, the money that is in your client trust account is not your money. It's the client's money. And upon termination, you are required, I'm sorry, I've been talking too much. You're required to deliver all client property, including that money, to the client. Now, you can deliver it to the client specifically or to the agent for the client. So this new counsel, if the client has agreed that the unearned fees in your client trust account are passed on to your new attorney, you're just following your client's instructions. That's permitted. But that money, until you've earned it, is not your money. It has to be treated as a client's property, and you either got to give it to the client or somebody the client instructs you to give it to.
Another question. Upon retirement and a new attorney has been selected and the client agrees to that new lawyer taking over the case, is it okay then to deliver the files to the new lawyer, or do they have to go back to the client and then back to the lawyer?
No, absolutely. The difference between an attorney in fact and an attorney at law, in my opinion, which may not be worth much, is an attorney in fact can only do what has been written down on a piece of paper that authorizes that person to do. An attorney at law, however, can step up and say, I have been hired by Joe Schmuckatelli, so from now on, you're dealing with me. And if an attorney walks into your office and says they've been hired by your former client and their former client wants them to pick up the file, that's good enough. You can turn it over to them. Of course, unless you suspect something's really amiss. But one of the benefits about being an attorney at law is that we are all honorable persons. We're recognized as officers of the court, and we can make that representation. So by all means, if the client has instructed and authorized, you can turn it over to anybody the client instructs you to do.
And one more question. On retirement, do the clients need to sign a new fee contract with the new lawyer?
That's probably going to be dependent upon how the client, but that's a relationship, or that is dependent upon the relationship that's created between the client and the new lawyer, I would say.
Yeah,
I don't.
Yeah, bear in mind Rule 1.5 of the Hawaii Rules of Professional Conduct require that you have written fee agreements now in Hawaii in almost every single circumstance, whether it's flat fee, contingent fee, hourly fee. You got to have a written agreement, except for really, really many small situations. So if you're the acquiring attorney, even though the case has been transferred to you under an agreement to transfer the case, you're still going to have a written agreement with the new client. Now, you may just ratify the terms of the prior agreement, but somebody's going to have to sign off, the client and the new attorney.
Thank you very much.
Anybody else with anything? One note for all of you, you belong to other sections behind Senior Counsel Division. ODC is really striving hard to get away from being a punitive organization, or what we call reactive discipline. We're trying to increase our focus on proactive work, where we stop problems from happening. And the best way to do that is through situations like this, where we sit down and we chat and we talk and we're available on the phone. So please, 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 if you have any bar group any law firm, any group of lawyers who would like to have ODC come and address a particular concern area, give us a call and we'll arrange something. We'll do Zoom anytime, any place, anywhere. If you want us on another island, we'll travel there. We got a budget for it, because if we can do something to help you avoid problems, then we don't have to prosecute you. And we don't really enjoy prosecuting lawyers, seriously. Okay. Thank you very much.
Thank you, Bradley. Thank you, Ryan. Always enlightening to hear from you.
Thanks for having us, Pat.